first of our Zoom meetings, and we're very delighted to have with us Olivia and Fiona, who are from McVeag, Fleming lawyers, and they're here to talk to us about wills and power of attorney. Really important concepts for everyone, no matter where you are in your life journey, but to understand what your rights are, but also what your responsibilities are, because at one time or another, those dear to us or ourselves may not be here. So we have to prepare things for our whānau so that we can ensure that both we and they are kept safe. So I'm Therese Island, I'm the National Manager. We've just got a couple of quick slides to show you about the generator so you know who we are and how we operate, and then we'll hand it over to our esteemed presenters today. So you've got the generator team here today. We look far more glamorous there than we do in real life. There's myself, June, Ngātai Papali'i, Alison, and Ray. And over the other side, we have some of our tuakana and expert coaches, and they're joining us today at the meetings as well. We are the generator, and we operate throughout the country. We help people who have a community services card and have a business idea. We help them and support them through whatever challenges they have to trial their idea and grow it into a flourishing business that supports them and their whānau. And this is where we operate throughout the whole of Aotearoa, and we have expert coaches and tuakana who help people on their way. So without further ado, I'll hand this over to Fiona and Olivia, who will introduce themselves and take you through this very important and interesting presentation.
Morning, guys. Thank you for joining us today. We've got a fair bit to get through and a few questions that have already come up. So hopefully we'll be able to answer any of the questions that have been burning for you guys. First, I just wanted to quickly check with Teresa. Were you wanting to do a karakia? I think that was on the agenda before we started, or do you want me to get into it?
Thanks, Fiona. Yep, we can do a karakia and then we'll hand it over to you.
Sure.
Let us pray. Our gracious Father, we thank you for this new day. We thank you for this opportunity to hear from Fiona and Olivia about the importance of wills and EPOAs. We pray that it will be a blessing for us and our families now and in the future. May you be with us and those who could not be here today and those who are yet to join us. In Jesus' name we pray. Amen.
Amen. Amen. Thank you. Do you want to just jump onto the next slide and we'll introduce ourselves? So I'm Fiona Faithful. I'm one of the partners here at McVeag Fleming. I'm based in our Albany office, but we do have offices in the CBD as well as out in Manukau. And I'm joined today with Olivia, who is one of our younger but very enthusiastic and very knowledgeable solicitors in our team. So yeah, we're grateful to be here today and to share a little bit of knowledge with you guys. So just a little bit about our firm, McVeag Fleming. So we've been around for over 105 years, which is a pretty big feat for a law firm in New Zealand. As I've already mentioned, we've got 3 offices, over 135 staff, and 39 practice areas. So we're a full service firm, you know, doing things like wills and enduring powers of attorney for private client, and then to the bigger commercial corporate work as well. It will be something that we're kind of looking at working with the generator on in the future, would be some more of the business orientated presentations as well. So I do a fair bit of work with Dementia New Zealand. Just a bit of a backstory, I guess, here as to why and how and everything. But my mother passed away with young onset dementia about 3 years ago now. And I guess that it gave me a real insight into not only the importance of these documents, but also the effect that dementia can have in people's lives, particularly those with young onset. Um, it can really change their financial position when you're not, for example, eligible for, the pension and things like that. My mum was 55 when she was diagnosed, and she passed away at 61. Um, but it meant that my father couldn't work to help look after her, and she obviously couldn't work either, which made money pretty tight. And those are really the years where you should be, one, earning the most that you're going to earn in your lifetime, and two, it's when you're making those inroads to save for your retirement. And those kind of really crucial years were taken from my parents, and that changed their financial position quite a lot. So one of the areas that we focus on in our relationship with Dementia New Zealand is on those young set dementia diagnoses. We offer their wills, enduring powers of attorney at cost price, and then a blanket 10% discount for everybody else who has a dementia diagnosis. We also actually do free enduring powers of attorney and wills for people who are recognised by Dementia New Zealand as in need. So we run those workshops about 3 times a year out of our Manukau office on the weekends for people to kind of drop in and get those important documents done. If that is, I guess, relevant to you, then I do ask that you reach out to your dementia advisor, and that they can put us in touch with each other and get that process started if that's something that you think you qualify for. Um, and then we work with amazing charities and organisations such as Generate, as well as More Than Money, and other people as well, to get as much information across to as many people as possible. So yeah, that's the main thing that we really are driving at the moment in this particular space. This is just basically what we're going to be going through today. So the first part of the webinar is going to focus on wills, what is and isn't included in a will, what you should be thinking about. Then also how the different structures of ownership, so joint tenants versus tenants in common, can also affect what we can and can't do in your will. Ways that wills can be challenged, and what happens if you don't have a will. I'll then be handing over to Olivia, who will run through enduring powers of attorney and say, what they are, why we need them, as well as what happens if you lose capacity without an enduring power of attorney in place. There should be plenty of time for questions at the end as well. I will ask that we hold those questions to the end, particularly because I do find that people have their own specific questions that they want answered, and they'll put them out in the first slide when I might cover it in a couple of slides' time. We have received a few that have been submitted before the presentation as well, so we will go through those. So firstly, the last will and testament. So what is included in a will? So you'll see that we've got a little image here for you of all the different types of things that you should be thinking about. We'll start on the top left with revocation of prior wills. So obviously you don't want to have a contradiction between some old document and a new document as to which applies and things like that. So the first thing that we have is we're making sure that the will that we're doing today is the only document that needs to be referred to when dealing with your estate. The next point is your specific gifts. So usually these are things that have emotional value rather than financial value. They might have both, but a lot of the time it's really the emotional connection that makes these to be included into a will. So things like engagement rings, or something that a grandmother has given and passed down the generations. Family Bibles is another one that we see quite often. So yeah, it's often those kinds of things that can be a monetary amount, but most of the time it is a specific item that has significance to the family. The next one is who is to be your executor. Now, the executor is an administrative role only. Their obligation is just to carry out your wishes and your will. So they need to know what your estate is. So they need to know who you're banking with. Do you have a life insurance policy? All of those kinds of things. But they should also have knowledge of who the beneficiaries are. So obviously their role is to gather up everything, pay everything that needs to be paid, and then pay out the balance to the beneficiaries under the will. Yeah, so generally the executor doesn't have any discretionary powers to change anything in a will or anything like that. You may have things like your executor can determine who gets your personal effects for anything that isn't specifically gifted. So there is some small elements in there that an executor might have a discretion for, but for the most part, it's literally just an administrative role. So someone you trust and someone who has knowledge of your estate and your beneficiaries. A digital legacy. This is more relevant for younger people, obviously, than older people. So your executor can deal with your different accounts and things like that. But this is more to specify any wishes that you might have as well in relation to your digital legacy. So it might be that you may know somebody who has a Facebook page that's still active, and they're no longer with us. Is that something that it's your wish to have, or would you want it to be closed? And things like that can also be included in here. The next one there was the funeral instruction, organ donation, burial, cremation. Now, generally, all of these things are things that you obviously need to talk to your family about. They can be in your will, and often you will see them in your will. But often those decisions are already made, everything's already done before your will's actually consulted. So just making sure that your executor and the important people in your family know what your wishes are in respect of funeral instructions and things like that. Otherwise, when they read the will, it might be too late. The middle one there around transferring powers relating to control of a trust, obviously only relevant if you have a family trust in place, but often you will be able to appoint a trustee in your place and also separately transfer the power to appoint and remove trustees or beneficiaries of that trust. And that person will essentially have the ultimate control of the trust running forward. So again, that's a really important tool if you have a will that works alongside a trust. We will kind of discuss trusts a little bit further along in the presentation as well. Forgiveness of debt. So if anybody owes you any money, do you want that to be repaid to the estate, or do you just want it to be forgiven on your passing? So that might be loans to family members and things like that, or it might in fact be loans to a trust that you're forgiving. Provisions for blended families. This is probably where wills get the most complicated, is trying to deal with the number of scenarios that can come up when you have blended families, when you have parents who have gotten together, particularly later in life, where they have children from separate marriages, or when you have people coming together younger in life who have had a previous family and then start a family together, and how are we dealing with those different interests between the different children and things like that. Guardianship. So if you have any children who are not adult children, then you need to be appointing a guardian. So a guardian doesn't necessarily mean that they're going to be the person who are looking after and raising your children, but it's the person who has that decision as to where they live and what school they go to and those kinds of things, what medical procedures, all of the things that a parent would usually decide. And finally, gift of your residuary estate. So that's everything else that isn't specifically gifted away, or obviously paying any debts of the estate as well. Now you'll see down the right-hand side there, we have a whole lot of other considerations that need to be thought about when you're thinking what you should and shouldn't include in a will. And I guess it's a really good demonstration of how many different areas of law a will can touch. So the first one is domicile and overseas assets. So You can have two types of domicile. You can have your domicile of origin, i.e., where you were born, and domicile of choice. So if you choose to move somewhere permanently, then that's your domicile of choice. And there can be a bit of conflict in laws as to what would apply to different assets and different people based on where they are domiciled. Um, so that's an important thing if you are unsure where you're domiciled, or if you have a whole lot of assets both in New Zealand and overseas. You can have two wills that are, one in New Zealand that deals with the New Zealand assets, and one overseas in the other jurisdiction that deals with assets in those jurisdictions. Or you can have a will in New Zealand that deals with all of your assets, and in the other jurisdiction, you would need to go and get probate resealed over there to affect your will. But obviously, all those rules and regulations depend on where those assets are. So that's another complicating factor for when you're thinking about wills. My general advice, particularly if the overseas assets aren't somewhere like Australia or the UK, is that you should just have two wills, one in New Zealand that deals with your New Zealand assets as per New Zealand laws, and a separate one that deals with your overseas assets in that jurisdiction. The next point is one that always gets a lot of people thinking and talking, which is that when you get married, if you have a will in place, that will comes to an end. So a lot of people will have a will in place and then they've got married and they have no idea that they don't actually have a will anymore. Now you can circumvent that somewhat by drafting a will that is made in contemplation but not conditional on that marriage. So you can get around it if that clause is there. But most of the time, if your will is made before you're married, it will no longer be valid and you need to do another will. The next point is potential challenges to an estate. So how you structure things and what gifts you may or may not want to give. You need to think about whether or not that will create a potential challenge to your estate, and we'll go over that in a few slides' time. And the next one is your current ownership structure, which is actually the next slide. So if we just jump onto that. So you can own property in two ways in New Zealand. You can own things as joint tenants. That means you own all of the property together as one. There's no divided shares. You just own all of it together. That's how joint bank accounts work. But with property, real estate, it's one of the options that will appear on a title where your names are just next to each other. Now, for joint tenants, the right of survivorship applies. So the person who survives the other automatically gets that property. It doesn't go as per your will. So anything that you own as joint tenants will not be governed by what you have in your will. It will automatically go to the other person who's also on the title to the house or also on the joint bank account. The second type of ownership is tenants in common, and each party owns a defined share in the property. So on a title, you'd see, person A as to a 1/2 share and person B as to a 1/2 share, or whatever the share may be. You can see in that diagram, we're not quite at the 1/2 share there. And in this situation, when somebody passes away, the property is dealt with as per your will, and the right of survivorship does not apply. So you can see there that red person has left their share of that property or their interest in that property as per their will to two people, probably two children there. So you've got one person who will then be in common ownership with two other parties. So different challenges to estates. Probably the biggest one is relationship property. So a surviving spouse, so if you are the first to die, then the survivor of you, it doesn't have to be a spouse, I should clarify, it could also be a de facto partner, has a choice. They can either choose to receive what they are entitled to under the will, or they can elect to make a relationship property claim against the estate. Now, what they're entitled to is a very specific area of law that I don't specialize in. So I won't be giving any detailed advice on that. But basically, those relationship property rights arise relatively early on in a relationship, and it is based on a complex number of criteria. So it might be just that you're living together, but it's also about how you're dealing with your finances. Have you got joint bank accounts? Are there kids? There's a lot of different criteria that feeds into that matrix. So it's not just a hard and fast, you live together. It's not a hard and fast, you've been together for 3 years, which often people think as well. So yeah, there's a pretty complex matrix feeding into that question as to whether or not they're entitled to make a relationship property claim, and if they are, how much they're entitled to. So something to think about for sure there. Um, Testamentary promises. So these are promises that somebody's made in their lifetime, saying that they would leave somebody something, and a person has relied on that. So it might be, for example, that somebody has looked after some 2 years on the basis that they're going to get the house. If that is something that actually has happened, then that does give somebody a claim against an estate. And then Family Protection Act claims. Now, each person has a moral obligation to provide for their children. So you cannot simply exclude all of your children from your will. They will be entitled to a Family Protection Act claim if you completely exclude them. The courts have made pretty varying decisions on what a child is entitled to. And again, it's a complex question based on the needs of that child and the relationship and a number of other factors. But usually it's kind of somewhere from that 10 to 15% each child is entitled to. So yeah, something to consider there. Maybe don't rule everybody out of your will. There are other ones there too around actually making the will itself. So we've got things like, did they have mental capacity at the time that they made the will? Were they under undue influence from somebody around them to make that will or to benefit somebody in a particular way? Improper signing or witnessing of a will. So there's very strict requirements under the Wills Act around signing and witnessing. And the existence of a mutual will. So that's when two people make a will based on, promises to each other to not change that will. You cannot then change a mutual will. So there are a number of other circumstances which can create challenges to an estate. So this slide's all about what happens if you die without a will. So intestate. The biggest thing is that you have absolutely no control over where your assets go. So it will be distributed in accordance with the Administration Act. Generally, that's to your partner and children. Then if you don't have a partner and children, to your parents, and then to your siblings. So with a surviving de facto partner or spouse and children, the partner will receive personal chattels and the first 155,000, and thereafter the partner receives 1/3, and the children or issues receive 2/3. So issues is a legal term meaning children or grandchildren, so someone in your lineage. There's obviously extra administration for us lawyers when we go through the process of getting letters of administration. So that includes requirements to advertise to find any beneficiaries under the Administration Act, so any unknown children and things like that, other relatives, as well as trying to find the will itself. So we need to advertise with other lawyers and things like that to see if there is a will. That obviously creates delays and extra costs. So yeah, we basically say that the cost of putting a will in place will easily pay for the additional time and cost involved in getting letters of administration versus probate for a will. So these are just some frequently asked questions that we get about how to structure things and how, how you can best plan for um, your own estate. So how can you prevent challenges to an estate? Obviously, the biggest challenge for an estate is relationship property, like we just spoke about. The best way to protect against that is a contracting out agreement. So you and your partner actually, while you're alive, determining what you are and aren't entitled to. So that would generally define what is your property, what is your partner's property, and what is considered relationship property, which you would share 50-50. So that's the general consensus of what those agreements do. And if you have one of those in place, it takes away that option of the surviving spouse making a claim under the Relationship Property Act against the will. Inter vivos gifting. So this is gifting while you're alive. So anything that you gift while you're alive, a gift is complete on acceptance. And the only real challenge to that is whether or not there's undue influence and capacity. And if there's no issues around that, it can't be challenged in the same way. So there's no requirement for, providing for children if it's gifted in your lifetime, or the testamentary promises because it's, no longer your property, things like that. Ownership of property through a trust. So if you have gifted everything into a trust, then it'll all be dealt with through the Trust Act rather than through your will because you don't personally own those assets anymore. So again, that's a good mechanism for preventing challenges, particularly if you're cutting out specific people. Yeah. Joy that I'll just specify though, owning things through a trust isn't a great protection mechanism for a relationship property claim. So it's pretty well established now that relationship property laws can cut through trust establishment so that somebody can still claim something, depending on the circumstances, that's held in trust. And joint tenancies. So, like we said earlier, when you have an ownership structure where you are both joint tenants rather than tenants in common, the right of survivorship applies and not your will. So if you set it up through a joint tenancy, it'll automatically go to that person. It doesn't go through the probate process. It doesn't go through the will process. That person just owns that property and it won't be subject to a challenge. How you can minimize time and costs of estate administration. Now, these are very circumstantial, so it depends on your personal circumstances as to whether or not they are actually appropriate, because some of them are, some of them are great mechanisms for some people, but just completely inappropriate for others. So the first is that probate's not required for estates with less than 40,000, effective from 24th of September this year. So up until that point, it was previously 15,000. So it's a significant increase, and I think it's well overdue. It was actually a change that was dictated by everybody having KiwiSaver, essentially. I think the average KiwiSaver account is close to 40,000. I think it was about 37, 38, and you can see that reflected in that threshold there. But it basically means that you're not going to definitely have to go through the probate process just because you've got a KiwiSaver. In that situation, obviously, it's still highly recommended that you have a will because you need to go through that letters of administration side of things. If you don't have that will, if you have a will, we don't have to go through probate, which is the process of getting the High Court to validate a will before you can action it. You can simply action it. So you can go to the banks and say, "Hey, here's the will. I'm the executor. I need that $50,000 in the will." In the not 50,000, 40,000, sorry, in the bank account, so I can distribute it to the beneficiaries. So yes, it's just an easier process. Now, technically, it is 40,000 cumulative. What we generally see, though, is that the banks and things like that will just look at what they have. rather than if, there's multiple banks. So that's a little bit of a grey area discrepancy as to how it's actually working in process. So yes. The second point there is holding major assets in a family trust or through joint tenancies, because it excludes it from the calculation above. So if you've got your family home, but that's owned through a trust or owned through joint tenancies, then that's not dealt with as part of your estate, and you can simply look at that, hopefully falling under that $40,000 threshold, so that your estate administration doesn't need to go through that probate process. Property held in trust requires very little legal administration, which is just usually updating the trustees on titles and in the ownership documents, and there's no time delay. So one thing that people don't really realize is that when somebody passes away, it's usually a couple of months until you get probate from the High Court to allow somebody to administer a will. From that time, you wouldn't have a final distribution from the estate until 12 months after probate is granted. So you're looking at about 14 months before you're going to get your final beneficiaries receiving what they're entitled to under a will. You can make distributions earlier, but it can lead to personal liability for the executor. So it's not something that is strongly encouraged, and it would never be a final distribution. So there would always be part of the estate held back for any claims that may crop up. That time frame is basically reflective of people's ability to make those claims to challenge estates through relationship property, through testamentary promises, or through the Family Protection Act. So my final point there is that these structures are not always appropriate. Joint tenancies are not appropriate for vulnerable people or people who have blended families and want to benefit their children. So for example, if you have a joint tenancy, but it's husband and wife and they each have children from a previous marriage, if you have a joint tenancy, your interest in that property automatically goes to the survivor, and they may just choose to benefit their own children, in which case your children would get nothing, which is probably not the structure that you're after. So it is just take those with a pinch of salt, and it would be ideal if you're looking at any of those options to have a discussion with a lawyer as to whether or not it's appropriate for you guys, and ensure that you understand the consequences of those structures. The last question is, do you need a lawyer to make a will? The technical answer is no, you don't. So enduring powers of attorney, which we're going to go through next, have a very strict process where you need to be independently advised by a solicitor for them to be valid. Wills do not have that same requirement. So they do not need to be drafted or witnessed by a lawyer. They do have very strict signing procedures that if you don't meet, you'll need to go to court to get the will validated. So it is really important that you do get it signed correctly, but also getting a will wrong can cost a lot of money in the long run. So while you don't have to have a lawyer, it's highly recommended that you do have a lawyer. I'm hoping that some of the things that we've kind of touched on over the last half hour have really demonstrated that while a will sounds like a very straightforward, simple document, there's actually quite a number of complex laws that all feed into what is and isn't appropriate to include in a person's will, depending on their own circumstances. So yes, I do strongly recommend that you talk to your lawyer about getting a will in place. So I'm just going to hand over to Olivia now, and she can take you through enduring powers of attorney.
Awesome. Yeah, so like Fee said, we're going to be going through enduring powers of attorney. They're also referred to as EPOAs or EPAs commonly. So I'll use those interchangeably throughout this. But basically, EPAs enable you to choose who you'd like to make decisions on your behalf should a situation arise later where you're alive, but you've been examined by a medical professional as being mentally incapable of making decisions for yourself, or you're unable to communicate those decisions. So, for example, you're in an accident or you're faced with an illness like dementia. So the person who gives the EPA is referred to as the donor, and the people who are nominated by the donor to manage their affairs are known as the attorneys. Really importantly here, you have to arrange your enduring powers of attorney before you become mentally incapable. So it's commonly thought that your spouse or your family automatically can manage your affairs if you do lose capacity, but that's not quite true, and you cannot put EPAs in place once you lose capacity. So there are two types of EPAs. One is for your property and the other is for your personal care and welfare. So an attorney acting in relation to your property is able to manage your property and your financial affairs. You can give your attorney a general authority to act on your behalf, or you can limit this and specify conditions or restrictions. For your property EPA, you can choose when the document takes effect, so only when you lose capacity or while you're still mentally capable. Some people can choose for the EPA to come into effect earlier, before they lose capacity. It can make things more flexible, so you don't have to go through the process of getting a medical assessment in order to activate that EPA for your attorney to act. And it can be also handy if you have a medical event that possibly limits you physically, but you still have capacity. That can make it difficult to act on, your property affairs. So your EPA can be handy there. So for property, you can appoint more than one attorney. Oh, I think we've just skipped forward one. You can appoint more than one attorney, and if you do appoint more than one attorney, then you have to specify whether they're going to act jointly or separately. And you can also require your attorneys to consult with and provide relevant information to certain people or family members before making the decision. So that decision still rests with the attorney, but they have to go through that process of consultation and/or information sharing. Now, an attorney acting in relation to your personal care and welfare is able to make those legal decisions about significant matters to do with your health. So that a significant matter can be one that has or is likely to have a substantial effect on your health and well-being or enjoyment of life. So a really common example of this is placing you in residential care or undergoing medical procedures. So for care and welfare, you can only have one attorney acting at a time. So the reasoning behind this is that in dealing with your health and welfare matters, we often need to make quick decisions. So having one attorney acting avoids any potential for conflict between attorneys. So giving over an EPA, it gives quite a bit of power over your property affairs and your personal care and welfare to your attorneys. So you need to be appointing someone you really, really trust that will have your best interests at heart. So if you do lose mental capacity without enduring powers of attorney, like I said earlier, your next of kin, your family, can't automatically manage your affairs. So in this case, an application under the Protection of Personal and Property Rights Act would need to be made to the family court for a welfare guardian that would cover your personal and medical decisions, and for a property manager for your financial decisions. Now, this process, it's quite lengthy, it's quite costly, and sometimes disputes can arise if you have people in your life or family members that don't agree with who might be appointed. So you can probably appreciate here that it can make already really difficult time more stressful. Urgent applications in these situations are available, but they still take time and there are costs. So if you don't have EPAs in place, doctors can make decisions on your behalf for medical emergencies, and they will generally consult with your family, but the family's decision or their wishes are not binding on the doctor that is making the decision. So welfare guardian orders often require the person to be, they do require the person to be wholly lacking capacity, but for property manager orders, they will allow partial capacity of the person. The court appoints what's called a lawyer for subject person, and the lawyer for subject person will meet with the subject person to obtain their views on relevant matters and report to the court. The judge will usually decide an application without the parties appearing in court. However, if the people involved, like your family, don't agree with the orders sought, then they can oppose them, and that would involve applications and possibly a hearing. So whoever is appointed as these guardians, they can't be paid, but they can recover reasonable expenses and costs. They are generally not liable unless they're acting in bad faith or they're failing to disclose that they are a guardian while acting for you. And these orders require review every 3 years. They'll expire if they're not reviewed, so that is also a requirement. Cool, so we'll try go through these quite quickly. I know we want to have some time for questions at the end. So the usual process for activating EPOAs, they can, for property, they can become active immediately, or like we said earlier, effective once the donor loses mental capacity. For personal care and welfare, they can only become effective once the donor loses mental capacity. The activation process is a reference to an assessment that confirms the donor has lost mental capacity and the EPA is effective. So part of this process is obtaining a health practitioner's certificate, and that's a requirement. So that contains the information prescribed in Section 5 of the Protection of Personal and Property Rights. And this can be done by a GP or, say, a geriatrician. They'll usually have a standard certificate they issue. Once the certificate is completed, it should be provided to the lawyer holding the relevant EPA documents, and they'll note that they've been activated, and then these can be provided to third parties.
I just want to add a quick point on that one, Liv, around making sure that you're using the appropriate person to make that decision. So if something is going to be challenged, or you expect it's going to be challenged, then it's really important that you actually have a geriatrician who's actually making that assessment rather than a general GP. That is their specialty, that they, it's part of their day-to-day routine is assessing somebody's capacity. So it's much harder to challenge a decision from a geriatrician than it is from a GP.
Cool. Thanks, Faye. So in terms of restrictions on who can be appointed, it's fairly simple. Your attorney has to be 20 years of age or older, and they have to have mental capacity, of course, and they can't be undischarged bankrupt. So like we touched on earlier, you want your attorney to be someone you really trust, to understand and respect your wishes and your feelings, who is also able to take that load of managing your property. So commonly this could be a partner or a friend or a family member. It can also be a work colleague or a professional person like a lawyer or an accountant. So an EPA is binding once all parties have signed and their signatures witnessed. So this includes all your attorneys and successor attorneys, and the certificate is complete.
Just a quick note on that one too, is that with the timing of it not becoming binding, we do see people who come in and see us and the attorneys sign themselves with us, and they take it away for the donor has signed with us, and they've taken it away for the attorneys to sign, who might be family members or friends or whoever it might be, and they take a long time to come back. Almost invariably, each time I do this, there is somebody sitting in the crowd going, "Oh, I thought it would be, I've done that and I haven't got the attorney to sign, and I thought it would be effective." So just hopefully a reminder for those who have done that to make sure they get them fully signed as soon as possible.
Yeah, that's a really good point. Everyone has to sign, and all witnessing has to be complete for that to be binding and effective. So with attorneys named that don't reside in New Zealand, we tend to recommend that any attorney you appoint does live in New Zealand, and that just makes things a lot easier in terms of contacting the attorneys, especially if attorneys need to be in person to sign anything, if signing over video call and things isn't permitted. And for having EPAs effective in other countries, because countries have their different rules around these things, it's unlikely that an EPA made overseas would be effective in New Zealand and vice versa. So an EPA made here in New Zealand would likely not be recognised in other countries. So following on from that, we recommend that EPAs are in place in any countries that you hold assets in. And so if it does arise where attorneys are needed, they can just manage your affairs. So can an EPOA sign as directors, trustees, or shareholders? The short answer here is no. An attorney cannot sign as a director or a trustee. They would instead be removed in that situation if they had lost capacity. For trustees, this happens under Section 104 of the Trust Act 2019. But an attorney can sign as a shareholder. This is considered a property decision.
Just another addition to that. So it's not about signing as a trustee, but depending on what your trust deed says itself, the power to appoint and remove trustees might be able to be used by an attorney, depending on the wording in the trust deed.
Cool. So at what point does an EPA come to an end? So you can cancel your EPA at any time as long as you are mentally capable to do so, so before you've lost capacity. And this is done in writing by notice of cancellation to your attorneys. So this can be as simple as sending your attorneys an email or providing them with the updated copies so they know they're no longer acting as your attorney. You can also suspend your EPA by written notice to your attorneys. An EPA can be cancelled by your attorney too. So if an attorney states in writing they no longer wish to act as your attorney, also if they pass away, lose mental capacity, or go bankrupt, they no longer act as your attorney. The family court can step in and cancel an EPA if a judge believes that the donor was pressured into appointing the attorney by undue influence or fraud. So if they're taking advantage of you. The family court can but doesn't have to cancel your attorney if a judge can see that maybe what your attorney is doing is not in your best interest, or they're not following those obligations of consultation and information sharing. And of course, an EPA ceases to have effect on your death. So EPAs are in effect while you don't have mental capacity but are still alive, and after your death, the authority to manage your estate passes to the executors named in your will. So some key obligations that attorneys are bound to abide by. It's fairly simple. An attorney is obligated to act in your best interest and promote and protect your interests. So a part of this is that your attorney must keep records of any decisions and actions taken. They must consult the donor and encourage the donor to make and communicate decisions. They have to follow, if specified in the EPA, they have to follow those obligations of consultation and information sharing to anyone named in those EPA documents. And there are also restrictions around what enduring power of attorneys can do. So for property, they've got quite a wide range of powers to sell property, access bank accounts, manage investments, and things like this. But they cannot take actions to benefit yourself or anyone else. You can specify certain conditions or circumstances where they can benefit themselves if you wish, but in general, they have to act in your best interests. They also can't recover any costs or expenses from your property, and they cannot continue acting as attorney if they're bankrupt or mentally incapable. So for personal care and welfare, there's also quite a few restrictions like we touched on earlier. It's decisions to do with your healthcare. So they can decide things like where you live or who will look after you, but they cannot make decisions for you around getting married or divorced or any decisions around adopting children. They can't consent to surgery or treatment of like brain surgery or any surgery or treatment like electroconvulsive treatment to change your behavior. They also can't refuse standard medical treatment to save your life or allow you to take part in any medical experiments unless it's seen as something that is vital to saving your life or preventing serious damage to your health. Also importantly here, your attorney can't refuse CPR if you need it. If you do decide you do not want to be resuscitated, you can make this intention known under an advance directive. It's also called a living will, but this needs to be made before you become mentally incapable. And as we just touched on earlier, any donor of an EPA has the ability to put specific restrictions or conditions into the EPA, which must be followed by the attorney. So I think this is our last question here is, can an attorney decide on assisted dying? So the short answer is no. From 7th of November 2021, a terminally ill person did gain the right to direct their doctor to end their life, but there is strict criteria around this. So it includes being 18 years old and above, suffering from a terminal illness that is likely to end their life within 6 months, be in irreversible physical decline with unbearable suffering, and be able to make this decision in an informed manner. So under this criteria, assisted dying is not available to those, for example, with a dementia diagnosis, and it's not available for people who have lost capacity under an EPA. So essentially, assisted dying can't be elected in advance. So you can't make a specification for your attorneys to make that decision for you.
Just jump back on there. Sorry, guys. One of the relatively common questions that we received ahead of this presentation involved what options there are to get affordable wills and enduring powers of attorney done. So obviously the first thing that comes to mind is the public trust. So they have very varying rates based on what services they provide. So you can get a very basic will for $69 through the public trust. It is very limited in what you can and can't do under that will. And to be fair, I think for 90% or probably 99% of people, it's not actually an appropriate will. So you can't appoint guardians for children. There's no ability to deal with any blended family provisions, no trusts, and estates must be divided equally. They do have comprehensive wills. This is actually incorrect. Sorry, guys. The comprehensive will, I think, is about $170. And it does cover most options that we were talking about as far as guardians, trusts, blended families. But it doesn't come with any bespoke advice or review, and no witnessing support, which has quite a high risk of making an invalid will. So it's not, again, my preferred option. If you are going to use the public trust, then you should choose the in-centre option, which is the pricing that's actually dictated there, the $750 per will. Now, that pricing includes meeting with a lawyer, having that witnessing support, and then, a review and discussion of your actual personal circumstances so that you can, I guess, ensure that your will have the effect that you want it to have, and you will minimize any risks for challenges against your estate. Now, one of the points that we kind of wanted to get across today is that it is a one-size-fits-all approach. There's no tailoring and things like that unless you go through that in-centre option. And when you are going through that in-centre option, it's actually pretty equivalent to just going to a lawyer themselves. we are prepared to offer wills to people on this seminar for $500 plus GST and disbursements. So that's a significant saving on what you will get through the public trust for a in-person or an in-centre will. Obviously, if it's completely out of reach, then it's still better to have a will in place than to have no will at all. I think it has its place in the community, but it's definitely not our recommended approach. The other side of the coin is obviously enduring powers of attorney. Through the public trust, again, if you go through the in-centre approach where everything's drafted and consulted, etc., it's $1,410, and we're willing to do those for $1,000. So yeah, we will essentially lower the price than the public trust to make sure that you guys get the best value out of these documents. They are incredibly important. People often overlook them. And I just can't say enough about how much help it gives your family and people like that in times that are incredibly stressful. Yes, so I think that that's the end of our presentation, so we can move on to the questions. Do you guys have in front of you the questions that were submitted ahead of time that perhaps we can run through first?
Cool. So I actually think I've got them up here if you want us to just get underway with that. So would you like to take that first one there, Faye?
Sure. So the first question is the amount of assets requiring a will. Obviously, we have actually been through that, which is that new threshold of 40,000. I didn't actually mention and should have that $40,000 limit is applied to investments like KiwiSaver and to bank accounts, but not to shares in a company. And if you hold any property, like a house, for example, you still need to go through that probate scenario. And then that second half of that question is if joint account holder can do any withdrawals or have to go through the court testamentary procedure. Okay, so a joint account is something that's owned as joint tenants. That means that the right of survivorship applies, and the other joint tenant will essentially have rights to that property from the moment that you pass. So you would simply need to produce a death certificate to the bank, and that surviving person would have full rights to the funds in that bank account. What if children are overseas? I'm not 100% sure what that question means. I guess for wills, obviously, you can still benefit people who are overseas. You need to think about inheritance tax in other jurisdictions. And I think we kind of covered off that you can have an enduring power of attorney appointing someone overseas, but the whole idea of it is to make your affairs easier. And I don't know if it's easier if you've got to send documents overseas.
Yeah, it's also probably worth noting the same kind of issues arise if your executors are living overseas. So issues with logistics and tax and things like that. So there's something to consider there.
It's actually a great point, Liv, because for the probate process, you have to have an affidavit sworn. So it's you definitely know that there's going to be some physical documents that need to be signed in person and couriered, which is not an ideal scenario.
And then the last half of that question.
How to navigate life policy bank accounts and other assets like vehicle, etc. Okay, so we'll start with a vehicle because that's probably the easiest one. But yeah, that will just go as per your will. So your executor will need to get probate if that's the the threshold level that you're at. before they can transfer the vehicle into their name, which should be the first step, and then to any final beneficiary under your will. Vehicles can't have joint ownership, as far as I'm aware, through Land Transport New Zealand. So that would have to be something that would be dealt with through your will, perhaps unless your trust owned it or something like that. Most of the time, trusts don't own vehicles or other items that depreciate significantly over time. So it's not usual that a vehicle would ever be owned by a trust. For life policy, so the biggest thing about that is who's actually named as the beneficiary on the life insurance policy itself. So you need to probably be calling your life insurance company and seeing who the beneficiary is and whether or not that's the appropriate person, because it could be to a surviving spouse. They could be the beneficiary of the policy, in which case it doesn't fall under the estate at all, or it could be a trust or something like that. So again, seeing if it can fall outside of the estate if that's appropriate.
Cool. So the next question we have here is, what is the process of an EPOA, and what is the age that people are eligible to become an EPOA? So we've covered this a little bit, but if we want to go down to the detail of the practicals, so for the process of the EPA, it would be taking instructions on who you would like to appoint, including successor attorneys, and generally we get those details of their addresses and contact numbers so that when they're activated, it's a smooth process from there. And there are strict signing requirements, like we've covered, around making sure that's all been executed properly. And again, it won't be binding until everyone has signed. And at the start of that process is, of course, the certificate from the health practitioner, preferably a geriatrician. And the age that someone is eligible to become an attorney is 20 years old. The next question we have is costs around EPAs and wills, and where you can find support for that. That's what we've just gone over in that last slide. So we went over the public trust costing. They are very affordable, and like Fee touched on, it's probably better to have a will in place than not, but they're not our top recommendation for that. And we have that offer for today for everyone joining this seminar.
Yeah, just with that one too, if you wanted to follow us up on that, just make sure that you mention this seminar and that pricing as well, so that we know to apply that discounted rate for you guys as well.
Cool. So I can let you take this last question, Fee.
What's the most cost-effective way to support whānau that have not yet been diagnosed but are being monitored? So there's kind of 2 points here. So the first is about the importance of getting documents in place really quickly when you do have those kinds of suspicions. Things can change incredibly quickly. And the last thing you want is for them to lose capacity before enduring powers of attorney are put in place. It's a nightmare cost-wise, time-wise, all sorts. It's a bit of a stressful situation that you want to avoid. So my first piece of advice is don't delay getting this done. If things are out of reach financially for you, then focus on getting that dementia diagnosis across the line. And then we can work with you to jump in one of our free South Auckland sessions. Generally, a diagnosis doesn't take too long to achieve if you're working in the right areas. And I guess, like for my mum, for example, it was a very delayed process because she was so young. But if you have your suspicions and you're actually, getting that across the line, then it shouldn't be too long to get that diagnosis. I imagine that the hardest thing is actually resistance from the person that you're thinking about. But yeah, perhaps again, pointing it towards yourself making your own process easier, your family, your loved ones, that can help. But the other thing that I find can be very helpful, and it's a tool that I used with my mum, because she was I've got nothing wrong with me. Um, it, I actually spoke to my dad and got my dad to appoint my mum at the same time. And while that was never really going to be an effective tool for my dad, it was the support that my mum needed to get her across the line.
Right, so that was the last of the questions sent ahead of time, but I see we've got quite a few in the chat, which is great. So we'll just start from the top there.
How long does the process take to get letters of administration for dying intestate? It depends on how busy the courts are, and also how many responses or non-responses we get through the process of advertising. So like I said, we need to actually advertise to find beneficiaries and to find potential people who should be administrators as well, and a will. So that process is the main delay. We usually advertise those through through the Law Society and things like that, which can be kind of a weekly, but generally usually more like a month, that you'd allow for responses and things like that, as well as with the beneficiaries, that's usually in newspapers. So those two things, I'd say at least a month delay on what you would take to get probate. Probate, you're usually a couple of months. So you need the death certificate, you need affidavits signed by the executors and things like that before you can lodge it. And then it depends on court processing times. They're relatively quick at the moment. I think it's about I think we got one back within a couple of weeks, not too long ago, but in the past, that sometimes that's been up to a couple of months, 2 or 3 months. If single, do the children get equal shares by Administration Act, please? Yes, they do.
So are enduring powers of attorney applications for dementia patients only? If I'm reading this correctly, my answer would be that anyone can put in place enduring powers of attorney. They're obviously very, very good to have in place in situations with dementia, but anyone can put them in place and, of course, are encouraged to do so.
Yeah, so it covers any type of loss of capacity. I mean, dementia is a massive umbrella for a number of things, such as Alzheimer's or frontal temporal dementia, or Huntington's disease, Parkinson's. It can cover quite a lot, but it can be far more wide-reaching than just dementia. So we can talk about somebody who's in a coma, for example, somebody who's had a stroke. Those are really, really common times when a power of attorney is used.
Yeah. They can also be used if you're in a position where you just can't communicate. That's when they can become handy, especially with property attorneys. Cool.
Okay, and
So I think that's
No, one other person.
So we've got what are person property? What does that say? Sorry?
Oh, I think it's what are personal property and real property.
Oh, okay. Right. So real property is real estate, housing, commercial buildings, so any land. And personal property is everything else. So personal property would be your bank accounts, so your financials, but also your personal effects, your clothes, your household items, cars, things like that.
okay. Number 5.
For domicile of choice, if dying overseas or executor is overseas, since video calls are not acceptable, is there no validity? It was also mentioned reselling to give effect. So for your domicile of choice, if dying overseas, I mean, I can't really touch on laws overseas, but generally, for you to have a domicile of choice. So if I lived in Australia, but I was still a New Zealand citizen, that doesn't necessarily mean that I'm domiciled in Australia. I can still be domiciled in New Zealand. Domicile only changes when you no longer have an intention to ever move back to New Zealand. So you're moving to Australia permanently. You have no intention. You essentially are cutting all ties with New Zealand. Generally for personal care and welfare, it's your domicile that the laws of that country would apply. That has created, and I don't know if this is what this question's kind of targeted at, but it has created some issues around countries where assisted dying is less regulated than in New Zealand, and people essentially flying overseas for assisted dying when they're not eligible in New Zealand. It could be that. So there is some conflict of laws arguments about whether or not New Zealand laws should still apply, even if you're in the Netherlands, to pursue assisted dying. That is a very detailed question, and I don't know if that's what the answer is there or not. Or an executor is overseas, since video calls are not acceptable, there's no validity. So if an executor is overseas, we literally have to post documents over there. They will need to sign with a notary public and send them back for us to, get their appointment as executor through the probate process. So it's still valid. It's just a harder process and a more costly, expensive process for the lawyers involved in getting probate. It was also mentioned reselling to give effect. I'm not sure what that question's directed at.
Yeah, I'm not sure either.
Yeah. Okay.
Well, Yasmin, if you'd like to rephrase that, we can get to it at the end if we haven't answered it.
Who should be the first contact for the beneficiaries, please? So I guess the executor is the first contact for the beneficiaries, and your executor obviously needs to know who your lawyer is, where your will's held, because they're the person who's going to get in touch with us to let us know someone's passed away. They'll be organising and providing us the death certificate usually. So yeah, their first point of contact is the executor. The executor's first point of contact is the lawyer. Obviously, that's on the presumption that probate or letters of administration are needed. Yes. Life insurance or handing over death certificate to bank for the joint account or lawyer, please.
I think that's also referring to who the contact is.
Oh, right. Okay. So again, so your executor is the person who has those rights to deal with the bank and for the life insurance and things like that. We might be helpful in far as administrating that. I guess asking the right questions, knowing what to say and things like that, but they won't be dealing with the lawyer. They'll be dealing with the executor. So for example, I'm dealing with an estate at the moment where I've spoken to the not the financial advisor, she actually invests for the estate, and kind of got instructions on what the best options are, conveyed that to the executor, and the executor then needs to come back and confirm that that's what they want to do with the finance company. So it always needs to come back to the executor. For the joint account side of things, like I said, that falls outside of your estate, so it should be simply providing a death certificate, and the other person on that joint account can do that and then take over that account. Do you have a price/cost to activate PPR? That one, it doesn't have a legal cost at all. So the process is getting that certificate from a health practitioner to say that capacity has been lost. You can do that through the public system, so there might not be any cost involved at all, or you can do that through your GP if that's appropriate as well, or a private geriatrician, which would have a cost. I don't know what they charge, to be honest. Do you recommend gathered here free wills? So the biggest thing about the free wills is that they are just a template, and it doesn't ever take into consideration all your different circumstances. They are almost never appropriate for a blended family. Just because you know it won't deal with relationship property claims or things like that against your estate. So there is a bit to think about there. I don't recommend I don't recommend using any kind of free will template. I always recommend going to a lawyer, but I also understand that that's out of reach for some people. So for enduring powers of women, sorry, the question, drafting a will and enduring powers of attorney, are there formats available to guide people to begin writing up a will and enduring power of attorney ahead of seeing a legal rep? Yes, there is absolutely. So enduring powers of attorney are actually all on a standard form. It's a prescribed form. It also has detailed instructions on the back of them as to what the different options mean, explaining why they are options and things like that. So enduring powers of attorney, absolutely. There's a lot of information on them. I wonder if whether or not that's something that I can pass on to the generator for them to share out. I can't see any issues with that. They're, like I said, they're a standard form and there's standard instructions and explanation that goes with that. For wills, not so much. um, what we usually essentially put out a template that people answer a whole lot of questions to get us on the right track so that we can make a first draft to discuss. I would say that your best option would be to go through the previous slides that said what should be included in a will and, you know, write any instructions for those specific things. I would then look at the next one to see whether or not there are any potential challenges to your estate and write down what those circumstances are so that your lawyer knows what you're dealing with.
Yeah, and for EPOAs, you do need independent advice for those to be valid.
Yeah, so you have the templates, you can fill them out, etc. But if you sign them without a lawyer, they're not going to be valid.
Oh,
sorry about the confusion. It was around organ donation.
So that was for Yasmin's question.
Anyway, keep going.
We might just have to go to the next one.
Yeah. Got one more from Mirio.
It was also mentioned reselling to give effect.
Yeah. So resealing.
Oh, resealing.
Right.
Okay. So resealing is essentially when you have one will that you want to apply to New Zealand assets and assets overseas. So you go through the probate process first in New Zealand, and then in that other jurisdiction, you send all those probate documents over there and you get it resealed over there so that the courts essentially over there say, yep, you've got your probate requirements done in New Zealand and this can now be acted on in whatever that jurisdiction is. So that's what that process is. It depends on what jurisdiction you're in as to what those requirements are and the costs and things, but usually it's a lawyer over there who does the resealing. So that one's just asking if you will have links and recordings. So yes, this whole thing's being recorded. And yes, I guess if we can get, when we send the powers of attorney documents out, maybe we can get our contact details on there as well if you want to get in touch with us. Any more questions? I mean, I'm happy to consider other questions after the fact if they're not too specific to certain circumstances, and we'll provide kind of be informative to everybody else as well. We do work on quite a significant number of frequently asked questions that we try and publish as well, so they may be helpful for us to circulate at the same time. Cool.
Awesome.
I think that's everything.
Oh, the offer.
All right. Well, given that we're so close to Christmas, I don't want everybody flying in before Christmas. Want to make sure we actually get a holiday. But how about we say that, we'll maybe leave it open until the end of February. Someone's put there and only for those on the webinar. All the prices and things can and should be applied to partners as well, because they generally your wills are very reciprocal, as well as your enduring powers of attorney. If enduring powers of attorney aren't reciprocal, we do have difficulties in acting for both parties, so we won't be able to act for both parties. If two partners, if you're appointing each other, then there is an exception that we're allowed to act for the attorney and the donor. If you aren't appointing each other, we can't act for an attorney and a donor separately.
Awesome.
Okay, I think that's it, isn't it? Thank you very much, everybody, for joining us, and particularly Olivia and Fiona. It was extremely informative, and it's given people a lot to think about. So we'll be sending out the PowerPoint slides as well as a link to the recording. And as we say, also the information with regards to the offer, which is obviously something that a lot of people are interested in. An unusual Christmas present, perhaps, for your partner.
Yeah, it was actually just a last minute thing. We were kind of just like, oh, what kind of deals can we kind of get across the line to hopefully help those people who want to pursue getting it done. And I'm very happy to actually have been able to kind of get these prices secured for you guys, to make sure it's like below the public trust cost is hopefully representative of where we kind of sit with helping the community.
Thank you very much, Fiona and Olivia. And we wish you a very peaceful, restful, rejuvenating Christmas with your family.
Yeah, thank you, and to you.
Thank you.
Ngā mihi.
Thank you, everyone.
Thank you, everyone, for joining. We'll also send you a little link for some feedback, because this is the first of many, and we'd like to make sure we get it right.